Pursuant to the order of reference received by the committee on March 21, 2016, the committee will now proceed to the consideration of Bill C6, an act to amend the Citizenship Act and to make consequential amendments to another act. And before the clause-by-clause consideration begins, we have department officials here who would like to make a short clarification of some earlier testimony. Ms. Hubers.
Thank you, Mr. Chair. I would like to correct my response to Mr. Tilson's questions during my April 12th appearance about the new document seizure authority in Bill C6. Mr. Tilson asked about the grounds under which the new seizure authority could be exercised. During that exchange, I responded that in the Act it says that there have to be reasonable grounds to believe that the document is fraudulent, and then the regulations would prescribe the factors that could go into that, and then dealing with the detained document. I wanted to clarify that officers will rely on the authority in the Act to seize fraudulent documents if they have reasonable grounds to believe that the document is fraudulent and not the regulations. Thank you.
Thank you, Ms. Hubbers. And just before we begin the clause by clause, I'd like to provide the many new members of the committee with a few comments on how committees proceed with the clause by clause consideration of a bill. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to a clause in question, I will recognize the member proposing it who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the package each member has received from the clerk. If there are amendments that are consequential to each other, they will be voted on together as a package. In addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. The Chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. If you wish to eliminate a clause of the bill altogether, the proper course of action is to vote against that clause when the time comes, not to propose an amendment to delete it. As this is the first exercise for many new members, the Chair will proceed methodically to allow all members to follow the proceedings properly. If during the process the committee decides not to vote on a clause, that clause can be put aside by the committee so that we can revisit it later in the process. As indicated earlier, the committee will go through the package of amendments in the order in which they appear and vote on them one at a time unless some are consequential and dealt with together. Amendments have been given a number in the top right-hand corner to indicate which party submitted them. There is no need for a seconder to move an amendment, and once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments do not require the approval of the mover of the original amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it's voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill, and in order to reprint the bill will be required so that the House has a proper copy for use at report stage. Finally, the committee will have to order the Chair to report the bill to the House. That report contains only the text of any adopted amendments, as well as an indication of any deleted clauses. I thank the members for their attention and wish everyone a productive clause-by-clause consideration of Bill C6. Ms. Lee.
Thank you, Chair. I want to put forward a motion. So with your permission, can I?
Ms. Lee.
The motion is that each member who is not a member of a caucus represented on the committee wishing to participate in the clause-by-clause consideration Bill C6 be allowed to do so. that any amendments suggested by said members be deemed to be proposed during the said consideration, and that the chair allow said members an opportunity to make a representation not more than 5 minutes in total in support of all the amendments.
Thank you, Ms. Z. Debate? No. Ms. May.
Yes, Mr. Chair, as you'll know, this amendment, the motion just put forward by Ms. Zahid, is intended to deprive members of Parliament in smaller parties and any independent members, we don't have any at the moment, but it would apply to any future independent members, from the right that now exists within O'Brien and Bosk rules of parliamentary procedure to put forward amendments at report stage that are substantive in nature. So by creating and I would say it's a false opportunity, a coercive measure, to present amendments at committee, it's not, although on the face of it, it might appear to new members to be a friendly measure towards members of Parliament in smaller parties. It's actually an oppressive measure to deprive members of Parliament in smaller parties of the right to present amendments at report stage. In other words, if you don't pass the motion in front of you now, members of smaller parties will have the ability to bring forward amendments at report stage and will not have to show up at your committee protesting at every stage, as I assure you I will, being brought here for amendments which I cannot adequately present or defend. I also find it very confusing that in this instance I received a message from the procedural clerk on Friday afternoon that I would be welcome should I wish to submit amendments, to send them, and then the committee will decide how it would like to proceed. The motion that you have before you has time limits involved which are not met by the current circumstances. So I'm in your hands, Mr. Chair, but I wanted to make every member of this committee fully aware that I know that the Liberal members have been instructed to pass this motion. I find it offensive. I wish you'd reconsider. I wish the Government House Leader would reconsider. I'm perfectly content with the rights I have as a Member of Parliament, but this motion, which was developed under the last Parliament by the majority Conservatives, is one that oppresses smaller party members. It isn't an assistance of any kind.
Thank you, Ms. May. I call the vote. All those in favour? Opposed? Carried. I would also like to note that the department officials will be at the committee table for the duration to provide any consultation that may be necessary as we go through the bill sequentially. So I would now call Clause 1, which begins with NDP 1, NDP Amendment 1.
Thank you very much, Mr. Chair. In fact, on this amendment, it comes with a number of others, numbers 1, 8, 9, 11, 12, 14, 18, and 23 all together. And the purpose of this amendment, and this first one is actually a consequential amendment to the main changes, and it was aimed to bring back the old federal appeal court system prior to Bill C-24. This set of amendments, Mr. Chair, I will actually not be moving them because I have later on in another set of amendments, Amendments 10 and 21, that will be a better system of the appeal system that I would wish the committee to consider. It may be that the latter amendments, number 10 and 21, when I move those, they may be deemed to be inadmissible, and we will sort of deal with it at that stage. And if it's not admissible, I am very much hopeful that the government would consider taking those amendments and putting forward new legislation, perhaps in the fall, to address that as the issues of ensuring that there's a appeal process in place that addresses the many issues that the witnesses have brought forward would be put forward. So to that end, Mr. Chair, for clarification for committee members, amendments number 189, 11, 12, 14, 18, and 23, I will not be moving those amendments, and all of those amendments is to deal with a package of changes to bring back a federal court appeal system related to this bill.
Thank you, Ms. Kwan. So in that case, we'll move to NDP 2.
Okay, NDP 2 is an amendment. Sorry, let me just find NDP 2. Yeah. This is an amendment to deal with the statelessness as it pertains to second-generation Canadians born abroad. Committee members would recall that we had a number of organizations and individuals who came forward and presented to us why this needs to change. These organizations include the Canadian Ex parte Association, and they had sent in a written submission, the Canadian Centre on Statelessness, the Canadian Council for Refugees, the Canadian Bar Association, the Metro Toronto Chinese and Southeast Asian Legal Clinic, and the Ontario Legal Clinic. The amendment for this area, there are in fact 2 amendments related to this. And the goal here is to address the issue of what's known as lost Canadians, and those lost Canadians that remain after the previous governments to the Citizenship Act. Their citizenship has not yet been restored. While the previous government did address some aspects of these stateless Canadians, the legislation to the second-generation Canadian born abroad would not be considered Canadians, and so therefore potentially leaving them to be stateless. The implication for individuals that are impacted are particularly, for example, those who might have work obligations abroad. I think many of the diplomats and officials as such are particularly impacted with their children, for example. I won't reiterate all the comments that has been made by the various witnesses who raised this issue. With that being said, I move the amendment, number 2 in my name, and then reference number 8213672 on this.
Thank you, Ms. Kwan. Thank you, Ms. Kwan.
Sorry, and just for one further clarification, Mr. Chair, that there is another related companion piece to this as well, and I guess we'll deal with those separately then. I'll move that second amendment separately.
It's up to you, Ms. Kwan. If they're related, we can deal with them together.
Okay.
Being advised, as they arrive separately in the package, it's probably at this point easier to follow the package amendment by amendment.
Okay, I'm happy to follow your instructions, Mr. Chair.
Thank you, Ms. Kwan. In regards to NDP 2, the amendment seeks to amend Section 3 of the Citizenship Act. And as the House of Commons Procedure and Practice, second edition, states on pages 766 and 767, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act unless the latter is specifically amended by a clause of the bill. Since Section 3 of the Citizenship Act is not being amended by Bill C6, it's therefore the opinion of the Chair that the amendment is not admissible.
May I make a comment, Mr. Chair?
You may.
Not challenging the chair. Thank you very much for that ruling. Just wanted to put on the record, though, that I do hope then that the government and the minister would take into consideration bringing forward in the fall a piece of legislation that would include addressing the issue of statelessness as has been indicated here. Thank you very much.
Thank you, Ms. Kwan. Ms. Kwan, you have the next amendment as well, NDP 3.
Thank you very much, Mr. Chair. This amendment, NDP number 3, is also an amendment to address the issue of statelessness. In particular, this amendment is attempting to prevent individuals from becoming stateless. And again, we have had a number of organizations who presented to us to raise their concerns around this and felt that there needs to be action taken with Bill C-6 to fix the problem. These include the Canadian Centre on Statelessness, the Metro Toronto Chinese and Southeast Asian Legal Clinic, Dr. Patty Leonard, the Canadian Council for Refugees, and the Ontario Legal Aid. The issue, as I indicated, is trying to address the concern that people or individuals, to prevent individuals from being stripped of their legal status in Canada, resulting in them being stateless. The notion of statelessness is not considered as factored in the assessment of granting citizenship, which presents a challenge with respect to applying for Section 5(4) grants. It challenges one's legal existence by nationality, citizenship, or birth certificates. And so to that end, this amendment is attempting to fix that problem accordingly. One of the issues that has been raised, which I thought was particularly useful for consideration, is this. And this is from the Ontario Legal Aid Association, and Andrew Bauer actually said, and I quote, "We're certainly hopeful that the new government's renewed recognition of the importance of international law and global engagement will result in our signing the 1954 Convention related to the status of stateless persons. But there is something we can do right now with this act to make sure that we're better protecting stateless persons and coming into better compliance with international law and norms." And to that end, 3 recommendations were made to which these amendments speak to, and that is to provide a definition of statelessness within Section 2A of the Act, and then it also asks to include both a de jure and statelessness as well as a de facto statelessness. And so practically speaking, the whole point of dealing with the statelessness and assisting stateless persons to get protection is to make sure that every member of society has a connection to a state. There are concerns that have been expressed by various people, including a case in the United Kingdom that shows the problems when we have an overly legalistic and narrow definition of statelessness. And so that's what these amendments is aiming to fix. And again, this is an issue I think crosses all partisan lines, because those are constituents that are in everywhere, in every part of the community. So I move the amendment in my name, Mr. Chair, amendment number 3, reference number 8223108.
Thank you, Ms. Kwan. Similarly to my previous ruling, the amendment seeks to amend, in this particular case, Section 2 of the Citizenship Act, which is not being amended by Bill C-6, and it is therefore the opinion of the Chair that the amendment is inadmissible.
Thank you again, Mr. Chair, for that ruling. I appreciate that clarity, and again, I would advance and hope that the Minister would consider taking this set of amendments and bringing that forward in the fall, again, to address a nonpartisan issue, but a critical issue impacting a number of people in our communities today.
Thank you. So we'll move on to NDP Amendment 4.
Thank you very much, Mr. Chair. NDP number 4, and this amendment seeks to provide a path to citizenship for youth under 18 years of age without a parent or guardian that is or is in the process of becoming a Canadian citizen. And again, a number of organizations presented this to us during the witness stage of our committee meetings. That included the Justice for Children and Youth, the Canadian Council for Refugees, the Metro Toronto Chinese and Southeast Asian Legal Clinic, an individual named Richard Kirtland who showed up at the committee, and also UNICEF Canada. The goal of the amendment is to ensure that young people without parents or guardians that are or are becoming Canadian citizens have a path to citizenship beyond having a less secure status and waiting until they turn 18. It was presented to us that, for example, for a variety of different circumstances, an individual may well not have a parent here in Canada where they could help them make an application. And to that end, they should not be discriminated against in having access to make application for citizenship. And this amendment seeks to address that, Mr. Chair.
Thank you, Ms. Kwan. And the chair rules this amendment admissible.
Victory.
Ms. Rimpel.
Mr. Chair, I believe this is very similar in scope and nature to an amendment that I presented as well, that will be discussed later, and for the same reasons we support it.
Thank you. Mr. Chen?
Mr. Chair, through you, there are several reasons why we cannot support this amendment. First, the Minister has already the authority to waive the age requirement under Section 5(1)(b) so that minors can apply for a grant on their own behalf. With this authority already in place under the Act, it's not necessary to introduce this amendment. Secondly, I would be very concerned about the unintended consequences given the lack of clarity, including around family law issues and the definition of custody. It's not clear what having control of the child means, nor whether the term custody covers all of the possible scenarios. Third of all, the proposed amendment lacks parameters that would help guard against possible mischief or work possibly against the best interests of the child. For example, it's not clear whether it would apply only to minors who lack a parent or guardian, or whether it could also apply to minors who are estranged from their parents or guardians. Additionally, the proposed amendment does not recognize the fact that a minor would be able to apply for citizenship against the wishes of his or her parents or guardians. Finally, the amendment would not prevent parents or guardians from being able to coerce the minor into applying for citizenship, potentially against the best interest of the child. Under the current 5(3)(b)(I) one waiver, there is discretion to refuse a waiver to guard against possible mischief. And for these reasons, this motion is not supported.
Thank you, Mr. Chen. Ms. Kwan?
Just speaking to some of the points that the members raised, I think in particular in the amendment it actually says that to amend with the following language is 18 years of age or over unless the person is a child who does not have a parent or a person who has in law or in fact custody or control of the child in Canada. So it does say specifically about the circumstances in which a child under 18 could make application. So the scenario or the suggestion that somehow a child could make an application with a parent or a guardian who may not approve of such an application is actually, in fact, not relevant and not applicable. With respect to definition of how one could define a person to be in custody or in control of a child, there are actually a number of different applications that apply to define custody. And on the issue around control of the child in Canada, those would be, of course, children or individuals who are under 18 who is under the state's guardianship. In my own community, for example, we have a number of children who've been apprehended as such, and so therefore they are in the control of the state, if you will. And so I think it actually defines it quite clearly what it means to allow for this to proceed. At the end of the day, and let me just cite this, from the Canadian Council for Refugees. In the case of refugee youth in particular, they may be stateless. Under the Convention on the Rights of the Child, Canada has an obligation to protect the child's rights to acquire nationality, and this obligation is underlined, quote, where the child would otherwise be stateless, Article 7, end quote. This amendment that I put forward fixes this issue, and I urge the committee members to support it.
Thank you, Ms. Kwan. I would like to call the vote. All those in favor? Opposed? Sorry?
On division, please.
Yes, on division. We next have Green Party 1. Ms. May.
Thank you, Mr. Chair. And again, it's hard for me to put into words how devastated I am by the motion that was passed, so I will put on the record that I'm here under protest and would prefer to have tabled my amendments at report stage. But I do want to commend the Liberal government for this bill overall. I didn't get a chance to speak to it. I speak to these amendments one at a time. But let me say how thrilled I am to see the damage done in C-24 largely removed. That citizenship is a principle. Much in this bill is to be celebrated. It's doubly hard for me to be so sad at a moment when I thought I would be enjoying a sense of restoration of good principles in our Citizenship Act. But let me move quickly to this particular amendment before I run out of time. This amendment seeks to deal with criticisms that you've heard in the committee testimony, particularly from the Canadian Bar Association, that injecting, as we do here in sub 4 of section 1 of the bill, clause 1, my amendment is very simple. It essentially removes subparagraph 4, which sets out requirements for income tax returns and ties income tax returns to applications for citizenship. The Canadian Bar Association brief was very clear on this point. It's concerned that any innocent mistake in an income tax return could have a negative impact on citizenship applications, or could even cause confusion where someone applying for citizenship either delayed applying for citizenship or delayed filing their tax return because of, I think, an unnecessary linking of the two.
Thank you, Ms. May. I would like to pause for a couple of minutes so that all committee members can receive a copy of this amendment. As we're waiting for copies to be made, I noticed that food's arrived, and I'd like to note that this hearing may be running a little longer than usual. And just a reminder that the food is for those at the table, committee members, department officials, at the front of the table as well, so that they have an opportunity to grab something to eat, and just in case that we run over time. So it's strictly for people who are at the table. Thank you. I'd like to call the meeting to order. Everyone's received the green package at this point, and I'd like to call on Ms. May. And just prior, just a clarification, if PV1 is adopted, it would mean that CPC1 can't be moved because of a line conflict. And the reference number that's been issued for the Green Party 1 is 8223-209.
Mr. Chair?
Yes.
Just for members who might be wondering, you refer to it PV1 as Parti Vert. So that's the way the Parliament had chosen to deal with my amendments in the last session once the motion was adopted that you just adopted, which was originally the Conservative majority. So they didn't know what to do. They thought if they put green for G, it would get confused with government amendments. So Parti Vert, PV, is the way my amendments will be designated.
Thank you, Ms. May. Any debate? If not, I would like to call the vote. Oh, sorry, Mr. Tilson.
Just on a point of order on the issue that you just raised, that if this fails, CPC 1 fails.
No, the reverse, Mr. Tilson.
Right,
if it's adopted,
Yes.
then it fails CPC 1. If it's not adopted, we will proceed, and in fact, CPC 1
Thank you. I'm sorry, I misunderstood your ruling.
Okay, thank you. So I'd like to call the vote. All those in favor? Against? Thank you. So now we would move to Mr. Tilson with CPC 1.
Yes, thank you, Mr. Chairman. We're moving that subparagraph 51C3 of the Act be replaced by the following. Met any applicable requirement under the Income Tax Act to file a return of income in respect of 3 taxation years that are fully or partially within the 5 years immediately before the date of his or her application. This amendment, Mr. Chairman, came as a result of submissions by Mr. Curlin, one of the witnesses that spoke to us on this issue, and the principle of it is we want to ensure that someone's applying for citizenship are living here, and it's reasonable that we require that they file income tax as a resident during the same 3 in 5 period. And the clause as it now stands isn't clear on that. That was Mr. Curlin's comment. So this amendment would therefore emphasize that the applicant for citizenship file their income tax as a resident of Canada. That's the principle of it, and that's the principle of the amendment.
Thank you, Mr. Tilson. This amendment is admissible. Debate?
Thank you. If I could make a few remarks about this particular amendment. As you know, as things currently stand, with that provision, I think it can be concluded that it satisfies the worthy goals of, first of all, ensuring that that there is awareness of the need to file taxes, as well as the requirement of having an attachment to Canada. So that having been said, I would say that there doesn't appear to be any need to introduce this amendment. In addition to that, the other aspect of it that flummoxed me somewhat is the fact that this particular provision that's been proposed appears to add a physical residency requirement, and I don't think that's what we would intend to do. So I'm very much against it.
Thank you, Mr. Asasi. Mr. Tilson.
Just in response to that, Mr. Chairman, Mr. Curlin was commenting in response to issues that were raised about the comment of citizenship by convenience, that people apply for citizenship, and then they're gone. They just disappear. And we gave the example, I gave the example in one of my questions on the issue of Libya, where a number of people in Libya during the uprising, I don't know how many years ago it was.
Lebanon.
Sorry?
Lebanon.
Yeah, Lebanon, sorry. Lebanon. All of a sudden came back, which is like the first time they'd come back. So getting a Canadian citizenship is serious business. This is the greatest country in the world, and we should honor that. And people should honor their citizenship and not just get it for purposes of convenience. This is a serious issue. People can't just come and get that blue citizenship passport and then take off. And quite frankly, this was a suggestion made by Mr. Curlin. I think it's a good suggestion. Either they're serious about becoming a Canadian or they're not. Those are my comments, Mr. Chairman.
Thank you, Mr. Tilson. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment, to my recollection, a witness, Mr. Richard Kirtland, presented this and called for this change. And to my understanding, the amendment that Mr. Tilson is advancing is to allow for a person who is a resident in Canada be required to file their income tax in order to gain citizenship. I just want to make sure that that is, in fact, the intent from Mr. Tilson with respect to this amendment.
Mr. Tilson? It is.
Thank you, Mr. Chair. I actually support this amendment. I think it is important that if you're a Canadian and you're resident here, you should file income tax accordingly.
Thank you, Ms. Kwan. Seeing no further debate, I'd like to call the vote. All those in favor? Opposed? No? Okay. We will now move to PV2. Ms. May.
Mr. Chair, I'm in quite a quandary. I just had it clarified that the motion that was passed not only takes a page out of the Conservative majority playbook, it actually worsens the impact for people in my position by saying that I must speak to all my amendments for 5 minutes in total for any bill that comes before this committee. I have 8 amendments. That means less than 1 minute per amendment. And having assumed that it was 5 minutes per motion, I used up 1 minute and 42 seconds on my first amendment. So I'm quite, I have to say I'm shocked. So my second amendment, if I can speak to it quickly, is attempting to deal with some of the evidence that you had before you, both from the Disability Law Centre and from the Canadian Bar Association, that the requirement, an additional demonstration of the knowledge component, as well as the language test, which has already been taken, is unfair and discriminatory, particularly to people with disabilities, and fails to take into account the commitments that Canada has made for proper accommodation.
Thank you, Ms. May. Ms. Kwan.
Mr. Chair, just for clarity, the package that I received actually doesn't refer to the number that you cite, but rather a reference number. I wonder for each of these amendments that are being tabled, if you can say what the numbers are so we can follow it accordingly.
Thank you, Ms. Kwan. Yes, so it's reference number 822327. Seeing no further debate. Ms. Kwan.
Thank you very much, Mr. Chair. I do wish to speak to this amendment. This amendment is similar to intent with a number of other amendments that I put forward in my package, particularly with the language testing. And so while I think that in my amendments they're more specific in terms of its application, And so I'll get to those amendments when I come to it. And then there's also another separate amendment that I've advanced with respect to the issue around disability. And again, that speaks to the concerns that Ms. May had identified. So while I don't disagree with the concept or the intent behind this amendment, I am going to vote against it so that my other amendments that are more specific in its nature as it is applicable to each circumstance would be considered accordingly.
Thank you, Ms. Kwan. Seeing no further debate, all those in favor? Against? Negative. Thank you. We'll move on to PV3, which is reference number 8223-204. Ms. May.
Going as quickly as I can, this is in response to suggestions that were made before the committee from the Canadian Bar Association that we use this opportunity to clarify what we mean by a physical day and by bringing in reference to other subparagraphs to make it clearer.
Thank you, Ms. May. Seeing no debate, all those in favor? Opposed? Negative. Thank you. We will now move to CPC 2. And perhaps I should read the reference numbers. 8222-847. Ms. Rumpel.
Thank you, Mr. Chair. On April 8th, we heard from Justice for Citizen and Youth. They submitted a briefing to the Standing Committee in which they said, we're regularly involved with young people who are newcomers, including refugees who have either arrived in Canada as unaccompanied minors or who have experienced family breakdown such that they are in Canada without adult support and or without citizenship or permanent residence status. This amendment is in response to this particular comment as well as those that we heard throughout the committee hearings. The rationale behind this is normally a minor's application for citizenship is attached to that of their parent or guardian. The current provisions restrict access to citizenship for unaccompanied minors, children without parents or lawful guardians, and children with parents who do not have the capacity to meet citizenship requirements or who do not wish to apply. Often the department doesn't recognize child welfare authorities as the lawful guardian of a child for the purposes of citizenship application, which means children fleeing situations of abuse are also unable to apply for citizenship. Children who do not have a parent or guardian are already in a vulnerable position, and the current provisions in the law restrict minors from applying solely on the basis of age, regardless of if they meet all other requirements. So certainly this, I think, will rectify some of the comments that we heard during testimony on this bill, and I think have an overall net positive on Canada's immigration system.
Thank you, Ms. Rumpel. Debate? Ms. Kwan.
Thank you very much, Mr. Chair. I will support this amendment. This amendment is similar to the one that I had tabled earlier and was defeated. And the intent here is to provide opportunities for individuals under 18 to make application for citizenship. And many different individuals under different circumstances may not have a parent or guardian or may be a child of the state. And to that end, we should facilitate those opportunities for them to make application to citizenship. So to that end, I would support this amendment.
Thank you. Mr. Stroy?
I think it's a bit problematic. It technically can allow any minor to apply for citizenship, not just minors who have no parent or legal guardianship. Currently, the minister has the ability to waive the age requirement so that minors can apply on their own behalf. I think it'd also be very problematic. Somebody can come in as a permanent resident and the child can get citizenship right away, whereby their parents do not, and therefore it becomes a conundrum where the child is already a citizen and the parents are not. In addition, excuse me, I think it would not, sorry. Thank you, that's good. In addition, I think it would not prevent the parents or guardians from being able to coerce the minor into applying for citizenship, potentially against the best interests of the child. So I would vote against it.
Thank you, Mr. Sarai. Seeing no further debate, call the vote. All those in favor? Opposed? Negative. Moving on to NDP 5, reference number 8196267. And the chair rules this one admissible.
Thank you very much, Mr. Chair. On this amendment, and again, it addresses the issues around statelessness, as has been presented to the committee with respect to the concerns where individuals would not be deemed to have a state that they can claim to, and therefore are in a state of limbo, I guess, if you will. And this amendment seeks to rectify that, and it provides for provision that says, despite any other provisions of this Act, the minister may, in his or her discretion, grant citizenship to any person to alleviate cases of statelessness or of special and unusual hardship, or to reward services of an exceptional value to Canada. And so, to a degree, is a more narrow approach to addressing the issue of statelessness in my previous amendment, but nonetheless is one provision that I'm hoping that the committee members will support to rectify this problem.
Thank you, Ms. Kwan.
I'll move the amendment in my name, NDP 5, reference number 8196267, Mr. Chair.
Debate? See. Mr. Tabarra.
We heard from witnesses such as Legal Aid in Ontario and the Canadian Centre on Statelessness, who raised some very important issues, points regarding statelessness. I would have to say that statelessness is a factor in the consideration of humanitarian and compassionate grounds for grant of permanent resident status. By adding this clarity sends an important signal of Canada's tradition on responding to issues of humanitarian in a humanitarian way.
Thank you, Mr. Tabarra. Ms. Rempel.
Perhaps we could get clarification from the officials, because the way I read this amendment, this, if coming into effect, would mean that the minister could grant citizenship to a stateless person even if they don't meet the normal requirements for citizenship. So it would give the minister significant new powers in granting citizenship beyond the scope of the current Act.
Ms. Dekranian, or is it Ms. Hubers that will be responding or providing clarification?
It's okay, Mr. Chair. Yes, that is correct.
Ms. Rempel.
I believe that this is a significant overstep of what this bill was intended to do, and I think this gives a significant new power to the ministry to override our citizenship process. It actually decouples the principle that we should be letting public servants follow the process that we put in place in a very arm's length and neutral fashion. And I'm sure that the government will want to pass this, but I'm very concerned, and I think a lot of Canadians will be concerned that should this come into force, this actually politicizes our immigration system to a significant extent.
Thank you, Ms. Rempel. Seeing no further debate, all those in favor? All those in favor? Opposed? Carried. The next amendment is NDP 6, reference number 8214636.
Thank you. Thank you very much, Mr. Chair. This amendment seeks to enshrine in legislation the requirement for the citizenship process to adequately accommodate individuals with disabilities. We've heard from a number of organizations, including the Canadian Council for Refugees, the Arch Disability Law Centre, and the Ontario Council of Agencies Serving Immigrants on this issue. The goal here is to clarify the requirement of duty to accommodate those with disabilities as they navigate through the citizenship system. Currently, vague wording of required proof and discretion around accommodation can lead to individuals who would otherwise be able to become Canadian citizens being denied due to a lack of disability accommodation. And throughout Canada, in most aspects of society, there is a duty to accommodate up to the point it causes undue hardship on the accommodating entity. And this should be extended to the citizenship process, Mr. Chair. To quote the Canadian Council for Refugees, this is what they said: the current Act regulations and practice are quite limiting with respect to applicants with disabilities. The language and knowledge requirements for citizenship prioritize those eligibility criteria over and above other meaningful indicia of civic participation and result in a discriminatory effect. They impose an extra burden on applicants who cannot demonstrate those two criteria because of a disability. Accommodations for applicants with disabilities are addressed through waivers by the Minister on compassionate grounds provided for at Section 5(3) of the Citizenship Act. Given that exemptions are by law a matter of discretion rather than of right, there are no clear rules. Immigration, Refugees and Citizenship Canada provides some guidance for clear or visual impaired applicants to be exempt from these requirements, but the process and additional cost is burdensome. Apart from hearing loss, the instructions do not give precise information about what evidence of a disability should be submitted. And so I think these are important considerations. They are sound reasons. We don't want to create barriers for people with disabilities to access citizenship. This is along the lines of what Ms. May was trying to address, and my amendment states clearly for the purposes of this section, if an applicant for citizenship is a disabled person, the Minister shall take the measures that are necessary to accommodate the needs of that person. So to that end, Mr. Chair, I move this motion, number 6, reference number 8214636.
Thank you, Ms. Kwan, and the motion is admissible. Debate? Ms. Zaid?
Thank you, Chair. To some extent, I agree with Ms. Kwan. So my suggestion is, I know presently the immigration, refugee, citizenship takes into accommodation the needs of the citizenship applicants who have disabilities, and this would be reflected in the legislation with this amendment. Creating a legal obligation on the Minister to this effect would strengthen the right of the people who have those disabilities. However, I believe that if we can do change the wording of this amendment a little differently, in order to strike a better balance between recognizing the rights of the accommodation of the people with disabilities and the Minister's discretion. Therefore, I move to propose the following sub-amendment. 3.1. For the purposes of this section, if an applicant for citizenship is a disabled person, the Minister shall take into consideration the measures that are reasonable to accommodate the needs of that person. So this amendment proposes to create a legal obligation for the Minister of Immigration, Refugees and Citizenship Canada to consider accommodating the needs of the citizens who have any disabilities. As it stands, however, this amendment does not strike the appropriate balance between recognizing the rights of accommodation for people with disabilities and the Minister's discretion.
Ms. Zaid, if I could ask you to please repeat the wording so that we can get it down accurately of your sub-amendment.
For the purposes of this section, if an applicant for citizenship is a disabled person, the Minister shall take into consideration the measures that are reasonable to accommodate the needs of that person.
Thank you. Ms. Rempel, to the sub-amendment.
Perhaps I could ask my colleague that's moving the motion, as well as my colleague who, as perhaps as well get the department officials to comment on what in practice that would mean. Would that mean provision of different services. I just want to get a sense of what was intended in terms of what they mean by measures that are necessary to accommodate.
The citizenship application form includes some questions which asking applicants whether they have any special needs or not. So, yeah, or maybe I can ask the department official to give a more clarification on that.
Thank you, Ms. Zaid.
So yes, I can
Ms. Hubers?
certainly speak, Mr. Chair, to what the department does in terms of its current accommodations. We ask applicants on the application form to identify if they have a need, and we accommodate that need, providing wheelchair access, sign language interpretation, that we pay for, personal assistance, those kinds of things. I would also just point out that we are subject to the Canadian human rights legislation. So we take that into account in making sure we accommodate clients who have needs.
Thank you for that clarification. Ms. Rempel?
I'm just not clear what additional measures this would create, or what this given what the department officials just said. Perhaps Ms. Zaid, through you, Mr. Chair, could elaborate upon what additional measures would be created by supporting this particular measure.
Ms. Kwan was next on the list.
Thank you very much. Not speaking to the sub-amendment, but to my main motion. For example, to Ms. Rempel's question, what are some of the examples where a person with a disability would require some form of accommodation? It was pointed out by Jennifer Stone, for example, as one of the witnesses from CCR, that those with cognitive or learning disabilities can presently ask for a waiver from the language or knowledge eligibility criteria on compassionate grounds. And they feel that this is a backwards framework that is at odds with well-established human rights principles in terms of in terms of this process as it pertains to citizenship. Often it is the case that with disability, some of it is visible and others not so much. And for those individuals with disabilities that are not visible, they often too run into all sorts of barriers with respect to that. And so this is meant to accommodate those individuals. The ones or the examples that were outlined by the officials really clearly speak to the disabilities that we can all see and identify with, but it does not address, I think, those others who may have disabilities that are otherwise hidden.
Thank you, Ms. Kwan. Mr. Tilson?
Yeah, I mean, I guess we're thinking, you say these sections, and it sounds helpful. Is there a definition somewhere as to what a disabled person is?
I believe that's a question best put to the department officials.
Yes.
Ms. Cinnamon?
I'm not aware if there is a definition of disabled person in some legislation. It certainly is not in the Citizenship Act.
Is there a definition as to what accommodation is?
There is reference to accommodation in the Canadian Human Rights Act, as was already mentioned by Ms. Hubers, that already applies to many parts of the Citizenship Act process.
Yeah.
Thank you. Ms. Zaid?
I would, just to clarify Ms. Rumpel's question, by creating a legal obligation on the minister to this effect would strengthen the rights of those people who are facing disabilities.
Thank you. Ms. Rempel?
I would just ask my colleague to perhaps clarify, given that my colleague noted that there wasn't a definition for certain terms in this bill that perhaps makes this particular sub-amendment and the amendment itself overbroad, if the government would consider clarifying or defining some of those terms so it can be very clear what, especially in practice in terms of applying it throughout the public service, what those accommodation needs would be, as well as the scope, what sort of persons this would be applied to. And again, understanding the need to be compassionate and whatnot, it's just sometimes we put amendments forward here without the correct legal context or definitions and then see difficulties within the public service in terms of application. And that would be my concern on the sub-amendment.
Thank you, Ms. Rimpel. Ms. Kwan.
Thank you very much. On the question around the sub-amendment, I'm wondering, as we're talking about definition, reasonable, what is considered reasonable, I guess, is my main question to Ms. Saeed. If the member could clarify, please.
Ms. Saeed.
The disabilities can be different forms. I think maybe the officials are in a better position to explain that presently what are the adjustments you do for those people who request special consideration based on their disabilities.
Ms. Hubers.
Thanks, Mr. Chair. I've outlined the things we do in terms of providing access for people who have mobility issues, for providing sign language interpretation for people who are deaf, providing personal assistance where that's required. In terms of the requirement to meet language and knowledge, and those who may have a cognitive impairment, there is an ability to waive that requirement on compassionate grounds, which is used for those types of circumstances.
Thank you, Ms. Hubers. Mr. Virani.
I believe Ms. Zayed has given me some of her speaking time. The concept of reasonable accommodation is well entrenched in case law, particularly in human rights case law. We've already heard the department officials indicate that the Canada Human Rights Act applies to this legislation. Reasonable accommodation, injecting the word reasonable effectively is a modifier on the context of what accommodation is required. Without the word reasonable, it could purport to require all manner of accommodation, including all manner of costs. Reasonable accommodation in an employment context, for example, is used to modify the requirements that are placed on an employer based on their means, their resources, etc. And the notion of the issues of sort of disability in response to the earlier comments, in terms of whether disabled is defined and whether accommodation is defined. Because we're already interpreting this legislation under the lens of the Canada Human Rights Act, the terms of disability and accommodation would be interpreted from that perspective.
Thank you, Mr. Virani. Seeing no further debate, we will deal with the sub-amendment first. So all those in favor of the sub-amendment? Passed unanimously. Thank you. So we will now move to the amendment as amended. All those in favor? Nope.
Just a question on that to the Parliamentary Secretary and what was said by you and what was said by on the main motion.
Main motion, okay.
I can't see that far. The lady on the right.
Oh,
yes,
Ms. Hubers.
I'm sorry, Ms. Hubers. Because of what you've both said, isn't this amendment redundant? I mean, you're already saying, from what I interpreted as to what you just said, what both of you just said, this is already looked after.
I have outlined the accommodations that we do provide already to applicants, and we are subject to the Canadian human rights legislation. I can't speak to what additional, in law, what additional obligations this may pose.
Mr. Chairman, I just listened to what you both said and what was said about the motion, and it seems to me it's duplication. We're already doing these things, so why would this amendment be approved?
Mr. Virani?
So in fact, the question was posed directly to me. So what I'll say to Mr. Tilson is that that argument could be made, but that argument could be made with respect to lawmaking as a general proposition. Obviously, we are required to comply with the Constitution of Canada, the Charter of Canada, and the Canada Human Rights Act. When you entrench language such as this into the statute, what you do is you elevate the amount of importance that it is accorded by the government as an act of parliament. So that by entrenching disability rights into the Citizenship Act itself, it is emphasizing to Canadians that the Canadian Parliament and its government takes these matters of accommodation and reasonable accommodation more seriously.
Thank you, Mr. Virani. Mr. Chen?
Thank you, Mr. I would just like to add my comments with respect to the questions that have been put on the table. It in fact is very important for us to recognize that there are people with disabilities, and although we have legislation and laws that do protect their rights, it's very important that under the context of immigration, within the minister's discretion, that there be a legal obligation for the minister to consider these factors, and that is why I believe it's important for us to pass this.
Thank you, Mr. Chen. Ms. Rempel?
Chair, I'm just wondering if the officials could speak to if there have been any cases or if there's any pending cases right now where this change would apply, or if there's been cases where the existing statute has not been sufficient to clarify obligations under this section.
Ms. Ms.
Sorry,
Hubers?
could you repeat your question, Ms. Rempel?
Mr. Chair,
yes, sorry.
I'm just wondering if there have been any cases that the department has seen where this particular wording that we're considering would have an impact. If there have been cases that the department have experienced where the existing provisions and case law have not been sufficient that would justify this further clarification.
I'm aware there are cases where where people complain through the human rights complaint mechanism, and where we sometimes come to an agreement. For example, whether or not this would, result in a different treatment for that individual by virtue of the wording that's proposed here, it's hard to say hypothetically.
Ms. Rempel?
Could you give us a sense of the, if you can, the volume of this type of traffic?
I don't have a number of the exact number of Human Rights Commission complaints, but I'm sure the Canadian Human Rights Commission website would have an indication of examples there.
Thank you, Ms. Hubers. Seeing no further debate, I call the vote on the main motion as amended. All those in favor? Passed unanimously. Thank you. We now move on to PV4, and the reference number is 8223202. Ms. May.
Do you have it on the clock how much time I have for my amendments?
Approximately 2 minutes.
What's it? I beg your pardon?
Approximately 2 minutes.
Okay, thank you. Okay, and I have 4 to go. Well, this one is very similar in rationale to the amendment you just accepted. So I think that the issue here, which is very clearly to ensure that the Citizenship Act waiver provisions are consistent with the requirements of Section 15 of the Charter and of the Human Rights Act. We did have a lot of evidence before the committee of real-life cases of people having difficulty with the responsiveness of the department to requests for waivers, to responses and requests for medical dispensation for the medical opinion form. There have been delays and roadblocks to people with disabilities. My amendment would assist in making sure there was greater flexibility in accommodating the waiver of requirements for people with disabilities.
Thank you, Ms. May. Debate? Seeing no debate, all those in favor? Opposed? Negatived. That brings us to the end of amendments for Clause 1. So shall Clause 1 carry as amended?
Mr. Chairman?
Yes. Mr. Tilson?
Yes. The difficulty with that is the Conservatives are in favor of some of them and opposed to others. So if you're going to vote on the overall Section 1, Clause 1, I'd like to comment on some of the individual sections. I mean, it's difficult for us because we're actually in support of some of them and opposed to others. All right. Clause 1.2. This is the part of the overall repeal of the 4 and 6 residency requirement. We believe that as it stands, the requirement that stands now, people can better understand, help newcomers understand Canadian society, and it helps them to better integrate into Canadian society. And wouldn't it help if we left it the way it is to help people better understand Canada's social and cultural norms? And wouldn't this help people to experience these things? And wouldn't this time reinforce the value of citizenship? So I'm just saying, Mr. Chairman, that the amendment takes away the need to reinforce the value of Canadian citizenship. So that's with respect to 1 subclause 2. The 1.5, this removes the intent to reside provision, and the effect of it is that it no longer would have to sign a declaration on the intent to reside in Canada when applying to become a citizen. And I'm concerned that this clause would be interpreted as encouraging citizenship of convenience, and that is, once citizenship is obtained, someone could leave the country never to return, but retain the advantages of holding a Canadian passport. And this is their right, of course, but it sends the wrong message, Mr. Chairman, in terms of the value and obligation of Canadian citizenship. 1.6, and I suppose the same would be for 1.7. This is the changing the age from 14 to 17 and from 64 to 55, that those requirements would no longer be required by citizen applicants demonstrating their knowledge. This notion that citizens is to be able to speak one of our 2 languages is not unique to Canada. It has always been a feature of our citizenship law, ever since the first one was adopted in 1947 by the government of the day under Prime Minister Mackenzie King. This is because citizenship represents full membership in our political community. It implies participation in our shared civic life. It grants the right to self-government through voting to select one's own government, or by even running for a public office. One cannot do these things, Mr. Chairman. One cannot do these things fully if one doesn't have the ability to communicate with one's fellow citizens. And so this amendment takes away or reduces that requirement. Um, 1.8 repeals the intent to reside section. And I'm concerned that this clause would be interpreted as encouraging, and the same as I've just made previously, citizenship of convenience. And that is, once citizenship is obtained, someone could leave the country never to return, but retain the advantages of holding a Canadian passport. And as I said, this is their right, but it sends the wrong message in terms of the value and obligation of Canadian citizenship. Uh, 111, I'd make the same submission 112, I'd make the same submission. So those are my submissions in opposition, Mr. Chairman. The other subsections we support.
Thank you for that clarification of the Conservative position, Mr. Tilson. So I will now call the votes. Shall Clause 1 carry as amended? All those in favor? Opposed? Carried. Thank you. So we will now move to Clause 2. Oh, sorry. There is another new clause, 1.1, which results from Amendment NDP 7, which is reference number 8213690. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment deals with the second generation born abroad issue as well. And as I stated earlier on some of the concerns with respect to that, this aims to rectify or remedy the situation where a person born outside of Canada who was adopted by a parent referred to in paragraphs A and B of the Act and is either a Canadian or is either a citizen under prior legislation or the former Act, or was granted citizenship under paragraph 52A of the Act, as it read before April 17, 2009. And so in that respect, what this aims to do, as committee members may know, the amendments that was brought forward in around the April 17, 2009, abolished the provision on those born outside prior to them turning 28. But those who turn 28 after that period actually are now in a state of statelessness, or some would, I guess, call them lost Canadians, if you will. So this is another way to actually address it for those second generation born, to bring forward a provision to bring in all these individuals as Canadians so that they're not lost in the system per se. There was actually really good submission from the Lost Canadians, 2 small categories in need of better remedies that was presented to all committee members that outlines the history of this and the rationale of calling for this change. And so that we can prevent a situation where people are somehow lost in the system. I'd just like to also point out comments made by the Canadian Council for Refugees. And they actually stated that pertaining to this issue, there are no measures in C6 to address the unfair situations created by the 2009 amendments, and by denying citizenship to the second generation born abroad, Canada is creating a new set of lost Canadians and making some children born to Canadians stateless. A.V. Go, in her presentation as a witness, gave a really clear example of why this is a problem. And she says, and I quote, "Yes, I think there's an area that needs to be improved. For instance, I have relatives who the husband was born in Canada and the wife wasn't. They are both citizens. I was advising them that when the kids were born overseas, make sure it's the father who applied for their citizenship, because if they apply for citizenship under the mother, then the children may not become a Canadian citizen. I think that example highlights the unfairness of the situation. So I think certainly I would recommend that provision to be amended." So this kind of illustrates the flaws of the current Act as it stands, and this amendment proposed to remedy that, Mr. Chair. So to that end, I move my amendment, NDP number 7 in my name, reference number 8213690.
Thank you, Ms. Kwan. The amendment seeks to amend sections 5.1 and 5.2 of the Citizenship Act. And since sections 5.1 and 5.2 of the Act are not being amended by Bill C6, it is the Chair's opinion that the amendment is inadmissible.
Okay.
So I will now. Oh.
Just one quick comment then. I would then also urge the minister to take this amendment into consideration at a later time. It does capture a number of people. I think the estimates from some experts in the field are suggesting that there may be about 1,000 people that are in this kind of situation, and I guess as the days evolve, there might be more. But it is, I think, an important provision to address so that once and for all, we can deal with the issue of lost Canadians or statelessness in a comprehensive manner. The approaches that were brought forward before missed some individuals in that regard, and that was unintentional, by the way. It was missed because legislation was drafted and tabled, and then Parliament closed, and then it never actually got to the floor for it to go through the whole process. Had that happened, those who turned 28 would never have been in this current situation that they're faced with right now. And so this really actually brings back, way back, of an approach that was put forward, and then it wasn't dealt with appropriately, I think, by the House of Commons, and it gives an opportunity to do precisely that. So I hope the minister will take that into consideration at a future date.
Thank you, Ms. Kwan. As NDP 8 has been negatived because it was consequential to NDP 1, it was withdrawn, I should say. We have no amendments for Clause 2. So shall Clause 2 carry? All those in favor? Unanimously passed. Thank you. We're moving on to Clause 3. Similarly, NDP 9 has been withdrawn when NDP 1 was withdrawn because it was consequential to NDP 1. We will move to NDP 10. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment, NDP 10 in my name, reference number 822883, attempts to address the lack of procedural safeguards around the revocation of citizenship by creating a new process where appeals and reviews can be made at the Immigration Appeal Division. This amendment actually comes with two amendments, and the organizations that are in support of this change are many, and they include the Canadian Bar Association, the Canadian Association of Refugee Lawyers, the BC Civil Liberties Association, the Metro Toronto Chinese and Southeast Asian Legal Clinic, the Canadian Council for Refugees, an individual Peter Edelman, individual Stephen Green, an individual Audrey Macklin, the Ontario Legal Aid, and then also Richard Kirtland, an individual as well. The goal here is to ensure that individuals facing citizenship revocation for misrepresentation or fraud should have at least the same degree of procedural fairness and safeguards that are extended to individuals facing revocation of permanent residence or fighting a parking ticket. Prior to Bill C-24, individuals could appeal to the federal court. Due to the cost, duration, and availability of the courts, this has been called an inefficient system by many experts. The Immigration Appeal Division currently undertakes similar appeals and reviews of decisions for statuses such as permanent residence, and for that reason, this board is adequately situated to handle citizenship cases as well and can handle them more effectively, efficiently than the federal court system. These amendments would institute this concept, Mr. Chair, and it provides for a number of procedural processes in the amendment itself. So I won't go through all of those processes, but I do want to highlight a couple of them. One is that it allows for humanitarian and compassionate considerations related to the person to be taken into consideration in this process, and particularly in situations where the best interests of a child is directly affected. I feel quite strongly that that should be something that ought to be considered, Mr. Chair. With respect to making a report to the appeal division. So before that report is made, this amendment calls for the minister to provide the person with a written notification that specifies A, the person's right to make written representation, that the period within which the person may make his or her representations, and the form and manner in which they must be made, and C, the grounds on which the minister is relying to make his or her decision to make a report, and finally, the minister shall provide his or her decision on whether or not to make a report to the person in writing. And so by bringing forward these procedures, it allows for, I think, a better approach to revoking someone's citizenship, something as serious as citizenship, for notification to be provided to that individual as well. And so to that end, I won't go through every aspect of the amendment, but that's the thrust behind it, Mr. Chair, and I would move this amendment, amendment number 10, reference number 8222883.
Thank you, Ms. Kwan. Bill C-6 amends the Citizenship Act and another act in consequence. The amendment seeks to amend subsection 10.1 of the Citizenship Act. The bill seeks to repeal subsection 10.2 of the Act, whereas in subsection 10.1 of the Act, the Minister has the power to revoke a person's citizenship. The amendment brings forward a new concept by giving the Immigration Appeal Division of the Immigration and Refugee Board the power to decide the revocation of someone's citizenship. This would go beyond the scope of the bill as agreed by the House at second reading, and as the House of Commons Procedure and Practice second edition states on page 766, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. Consequently, it's the opinion of the Chair that the amendment is inadmissible.
Thank you very much, Mr. Chair, for that ruling. Just to put it on the record as well, this is a change that, as I've stated, many of the witnesses had called for. And to be frank, I think it's a better system, is a more effective system, is more a equitable system, and it is a more efficient system. And I've been given some indication that there is interest by the minister to address this issue, and in fact, during second reading and before this committee, the minister was asked this question specifically by me about addressing the appeal process, and the minister indicated that he would be inclined to make amendments accordingly, subject to the presentation of the witnesses. And so now that through the presentation of the witnesses, these amendments have been this amendment's been presented to this committee, but is deemed to be out of scope for this committee, and so I am hopeful that the minister will adopt these amendments later on in the fall to address this particular issue. And worthwhile to note as well, and as my last point, Mr. Chair, is that currently there are court cases right now challenging the provisions of this act. It would be remiss of the government to not address it through legislation and to rely on the courts to address this issue, and only to be forced to come back to make the amendments accordingly.
Thank you, Ms. Kwan. We'll now move to PV5, reference number 8223269. Ms. May.
I'm afraid I had the wrong amendment rate. Could you tell me which one you were on now, Mr. Chair, again?
8223269.
69. I have, all right, all right, 69.
Started the clock.
Oh, thank you. I was anticipating that. Have we looked at my previous amendment? Did I miss one? They're all on the same line, so they got rearranged. Okay, I'm sorry. Yes, Mr. Chair, on this amendment, this is to ensure that we remain compliant with the International Convention against creating stateless persons. So this is to clarify and to ensure that despite anything in subsection 1, the minister may not revoke a citizenship unless the minister is satisfied that on the balance of probabilities the person is a citizen of another country. It's quite essential that we do not create stateless persons. That is a commitment that Canada has made globally. Thank you.
Thank you, Ms. May. Debate? Seeing no debate. Oh, Ms. Kwan.
I'm in need of some clarification as to the intent of this amendment. Ms. May indicates that this is not so that we don't create individuals who are deemed to be stateless. Am I assuming correctly that by revoking someone's citizenship, that to revoke that person may then become stateless because they don't have status in their country of origin? Am I understanding this correctly, the logic behind that?
Ms. May.
I reject the opportunity to speak at this moment. I'll lose all my time for my other amendments.
Okay.
Sorry. This is an impossible situation.
Perhaps there is someone from the department that might want to comment.
If the officials, that would be helpful, but if not, I will have to make a decision as to how best to proceed, given that I don't have the full scope of the understanding of the intent of the amendment.
It's difficult to speak, Mr. Chair, to the impact of the amendment without seeing the wording of it.
Ms. May, the motion as was proposed by Ms. Zaid allows you 5 minutes in total to speak to the motions when you propose them. It doesn't limit you in regards to answers that are posed by committee members, questions that are posed by committee members.
Oh, thank you, Mr. Chair. That's a very useful clarification. In that case, I would be grateful to respond that yes, indeed, if a declaration is made that revokes citizenship, that the minister must be assured that there is a valid citizenship in another country. We can't, as a nation, create a stateless person. We have an international obligation not to do so under the Convention Against Statelessness. So while it's an obligation in law, given that this is the only section of the Act that allows a minister to revoke Canadian citizenship, this is an important protection to make sure the consideration that the minister turns his or her attention to the question of whether or not there is, on the balance of probabilities, a valid citizenship for that person in another country.
Thank you, Ms. May. Ms. Kwan.
Thank you very much. Then in that instance, I think the request from Ms. May is that the minister shall take into consideration the factor that the individual, on the balance of probabilities, that the individual is not a citizen of another country. So if that's the case, the amendment actually doesn't indicate that, but rather it says that the minister may not revoke a person's citizenship or renunciation of citizenship unless the minister is satisfied on the balance of probabilities that the person is a citizen of another country. So there's a difference, perhaps subtle, but nonetheless an important difference to automatically deem that the minister may not revoke versus the minister needs to take into consideration and take into account of that issue.
Thank you, Ms. Kwan. Seeing no further debate, I will call the vote on PV 5. All those in favor? Opposed? Negative. Next, we have PV 6, and the reference number is 8223275. Ms. May.
Thank you, Mr. Chair. This particular amendment seeks to repair the damage done to the citizenship process under the previous Parliament and Bill C-24. Prior to Bill C-24, a minister would always consider factors of equitable concerns. In the words of the Canadian Bar Association Immigration Law Section testimony to this committee, due to C-24, currently, quote, neither the minister nor the federal court has discretion to consider humanitarian or compassionate factors. Some form of safety valve is warranted for deserving cases. So the amendment I'm putting forward speaks to this, I think, absolutely crucial ability of a minister to exercise discretion. So again, it's no requirement of the minister to stop the renunciation of citizenship, but without this amendment, the minister, no matter how much he or she might recognize that the situation is, it would create grievous humanitarian and compassionate harm, the minister wouldn't have the power to decide not to renounce unless you give the minister this discretion by accepting this amendment.
Thank you, Ms. May. And PV6 is admissible. Debate. Ms. Kwan.
Thank you very much, Mr. Chair. I would support this amendment. This amendment was, in fact, a component within my other amendments in addressing the appeal process, which was to incorporate a humanitarian and compassionate component to the consideration of revoking someone's citizenship. As the entire package for those amendments were deemed to be inadmissible, and so I don't have a separate amendment dealing specifically with humanitarian and compassionate factors, but nonetheless that is consistent with one of my original intent with that package, so I would support this amendment.
Thank you, Ms. Kwan. Seeing no further debate, I'll call the vote. All those in favor? Opposed? Negative. Next, we have PV7, which is reference number 8223266. Ms. May.
Thank you, Mr. Chair. This again seeks to reverse and repair the damage done by Bill C-24 in removing the right of appeal for someone whose citizenship has been revoked. So given that this was supported by numerous witnesses before the committee, the BC Civil Liberties Association, the Immigration Section of the Canadian Bar Association, and the Canadian Council for Refugees, the new process under which we're working, created by C-24, creates essentially a paper process. There is only one opportunity is to seek leave to appeal to the federal court for a judicial review of the decision, but there's not meaningful oversight here to the decision a minister makes. So my amendment's very straightforward. It restores what we always had before C-24, is that there's a right of appeal to the federal court to a decision made by the minister under this act.
Thank you, Ms. May. And it is admissible. Debate. Ms. Kwan.
Mr. Chair, I will speak to this amendment. This amendment, in fact, is consistent with the original set of amendments that I put forward to restore the old federal court appeal system prior to Bill C-24, and that included amendments 1, 8, 9, 11, 12, 14, 18, and 23, if we were to address this issue comprehensively and to restore the process, the appeal process, back to what it was prior to Bill C-24. I ultimately did not end up moving these amendments because I have some understanding from the minister in his presentation at this committee, as well as in second reading and other conversations, that there is interest from the government in pursuing a better path. That better path would include enhanced amendments that is incorporated in what I call Carl amendments and under NDP 10 and 21 in the amendments that were deemed to be out of scope and out of order, Mr. Chair. So to that end, while I don't disagree with the need to enhance the appeal process. Many people have spoken to it, and they've raised very legitimate reasons as to why it needs to be dealt with. And given that we have an opportunity to bring in better legislation in this regard, I am hopeful, and I'm going to take a leap of faith that will happen in short order in the fall sitting of the House. And so to that end, I will not support this amendment, not because of its intent, but because I think a better amendment will be forthcoming at a later time.
Thank you, Ms. Kwan. Seeing no further debate, I will call the vote on the motion, on the amendment. All those in favor? Opposed? The motion's negative. Shall Clause 3 carry? On division? Oh, Ms. Kwan.
So just on a point of clarification on Clause 3, Mr. Chair, if it passes, and it will, accordingly, so that means that we keep the system intact as it is under Bill C6 as it is proposed with all the flaws accordingly. Am I correct in that understanding? Just want that on the public record.
The clause has not been amended. Consequently, it's proceeding the way it was written.
So if I may just speak to Clause 3 for a minute, and again to get this on the record. Mr. Chair, I'm going to vote against Clause 3 because I do think that there is fundamentally flawed. Amendment needed to be brought forward. I trust that it will be at a later date. With that being said, there could have been a better way to deal with an entire bill, which is, of course, for the government to repeal all of Bill C-24 and then bring forward provisions that are supportive within 24 as opposed to the other way around. That might save us a lot of grief. But in any event, we are here where we are at. So with that, I am going to vote against Clause 3.
Thank you, Ms. Kwan. See no further debate. I will call the vote. Shall Clause 3 carry? All those in favor? Opposed? Carried. Perhaps I'll suspend for a couple of minutes to allow people to grab a bite to eat in the back and to stretch your legs for a couple of minutes. The meeting is resumed, and we're on Clause 4. NDP 11, reference number 8194673, has been withdrawn, and there are no further amendments to Clause 4. So I'd like to call the vote. All those in favor...
On division.
Oh, on division. All those in favor of Clause... Oh, Ms. Kwan, sorry.
Thank you very much, Mr. Chair. Consistent with my comments earlier, Clause 4 also deals with the appeal process that needs to be remedied, as this is a flawed process, and so I will be voting against it, and then in the hopes of improved procedures will be forthcoming in the fall with new legislation.
Thank you, Ms. Kwan. All those in favor of Clause 4? All those in favor of Clause 4? All those opposed? It's passed, carried. NDP 12, reference number 8198152, which references Clause 5, has also been withdrawn. So we'll proceed to NDP 13. Ms. Kwan.
Thank you very much, Mr. Chair. On this amendment, sorry, let me just find the amendment here. This deals with, again, statelessness as well, and particularly in this particular part of the clause, it seeks to address the issue of deeming sections 10 and 10.1 not operable, so that to authorize any decision, action, or declaration that would render a person stateless or that would otherwise conflict with any international human rights instrument regarding statelessness to which Canada is a signatory. So this is a similar amendment to the one that Ms. Maid had put forward, but although I think is more precise as to what actions should be taken, and particularly pertaining to sections 10 and 10.1.
Thank you, Ms. Kwan. It's admissible. Mr. Chen.
Thank you, Mr. Chair. I wish to make 2 points on this amendment. First is that we must uphold as a country the notion that we must uphold the notion that revocation of citizenship is appropriate when it was obtained through false representation, fraud, or some other unsavory means. And I also want to make the point that doing so is completely in line with international norms and laws. As committee members might know, in 1978, Canada signed on to the 1961 Convention on the Reduction of Statelessness, and this convention allows Canada to revoke citizenship if it was obtained by misrepresentation or fraud. And Western countries who have also signed on to this convention do follow this practice, and therefore this amendment is not necessary, and I am not in favor of it because as a country we should be able to render someone stateless if they obtained citizenship in Canada through fraudulent or other means, other similar means.
Thank you, Mr. Chen. Seeing no further, Ms. Kwan.
Sorry, just in response, perhaps to highlight the points or to illustrate the points more clearly for committee members, the witnesses that came before us raised this issue as well around statelessness, and Ms. A.V. Go actually came forward and stated this, and I quote, "In our clinic, a lot of these stateless individuals are former citizens of Vietnam. Many of them have been in Canada for a long time. Some of them, for whatever reasons, sometimes have lost their Canadian permanent resident status at some point. Many actually have mental health issues, and they have some criminality linked to the mental health, lost their permanent residence status, and became stateless because they have no country to return to. So in those situations, this is what it's trying to remedy. In those situations, for example, what will happen to the person when you deem them to be stateless? They are nor here nor there. They can't go back to their country of origin. They can't be here in Canada. And we do have an international obligation to which Canada has signed on to the 1955 convention related to the status of stateless persons. If we're going to follow international conventions, as has been stated, then there has to be some provision to address that. And right now, as it stands, we don't have a provision to address it, and this amendment seeks to remedy that, Mr. Chair.
Thank you, Ms. Kwan. Mr. Chen?
Thank you, Mr. Chair. I am satisfied that the current process for citizenship revocation, which does allow the minister to, on compassionate humanitarian grounds, to as well consider personal circumstances, that is within the scope of the minister's power, and to me, the cases where there are circumstances that require that due consideration, it is within the minister's prerogative.
Thank you. Ms. Kwan?
Sorry, just on that point, actually, I don't think we do. In fact, the amendments that would remedy that to try to address that issue in the appeals process of revoking someone's citizenship have been deemed to be out of scope. We do not have those provisions.
Thank you, Ms. Kwan. Seeing no further debate, I will call the vote on the amendment, NDP 13. All those in favor? Opposed? It's negatived. Just times. As there are no further amendments to Clause 5, shall Clause 5 carry?
On division.
On division. All those in favor? Opposed? Carried. Clause 6. There are no amendments.
Just a curious point of order, Mr. Chairman. When I say it's on division, and you call the vote anyway, what does that mean? Does it mean whatever I say is irrelevant?
I wasn't quite sure how Ms. Kwan was intending to vote. Clause 6. There are no amendments to Clause 6. Shall Clause 6 carry?
On division.
Thank you. Clause 7. NDP 14, reference number 8198549, was withdrawn. Shall Clause 7 carry?
Sorry, Mr. Chair, just to speak to this once again, the amendment that I've withdrawn, again, deals with the change pertaining to the federal court appeal system. And again, because this matter is now going to be hopefully be addressed with new legislation. With that being said, this clause, I'm going to vote against it, just to be consistent again with respect to the requirement that needs to be changed.
Thank you, Ms. Kwan. Shall Clause 7 carry?
On division.
On division. Thank you. There's a new clause, 7.1, and it's as a result of NDP 15. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment, NDP 15 in my name, reference number 8213645, aims to amend the following, that it removes the power the minister currently has to indefinitely suspend citizenship proceedings to gather more evidence. This provision can indefinitely extend the length of the process, leaving potential citizens under duress as they are stuck in limbo waiting an undisclosed period of time while knowing that they are being investigated. The organization that made a strong argument as a witness before this committee to call for this change is the Canadian Bar Association. And I think that for a reasonable person, following proper due process, is unreasonable to say that you're being investigated and there is no time limit to which this could occur. Literally, this could happen until the day you die, and you're still under investigation because the Act, as it stands right now, allows for indefinite suspension of citizenship proceedings. I think that's inappropriate, and I think that needs to be addressed accordingly. And so, aside from the Canadian Bar Association, who made this suggestion, also representing the Canadian Bar Association individual, Chris Beeman, made some strong examples to the committee as to why this provision should be rectified. So to that end, I move this amendment, number 15, 8213-645, in my name.
Thank you, Ms. Kwan. The amendment seeks to amend a section of the Citizenship Act that is not amended by the bill. It's therefore the opinion of the chair that the amendment is not admissible.
Mr. Chair?
Yes.
I'd like to just then make a comment with respect to that. I certainly hope that the government the minister would take into consideration the witness's presentation with respect to this amendment. I think it is a basic principle that there should be some sort of time period in which someone's citizenship would be deemed to be inadmissible to be applied and for it not to be indefinite. And so I'm hoping that this will be addressed later on in the fall with perhaps a new legislation.
Thank you, Ms. Kwan. Moving on to Clause 8. There are no amendments to Clause 8. Shall Clause 8 carry?
On division.
On division. Clause 9. No amendments to Clause 9. Shall Clause 9 carry? All those in favor? Opposed? Passed. Moving to Clause 10. There is an amendment, NDP 17, reference number, NDP 16. Reference number 822291. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment, number 16, reference number 822291, seeks to extend application of the Youth Criminal Justice Act to the citizenship process. This amendment is problematic in this sense, and as presented in a brief to the committee from the Justice for Children and Youth, and they said, and I quote, Justice for Children and Youth's position is that the Citizenship Act should clearly prohibit the use and consideration of youth criminal justice records in any matter governed by the Citizenship Act, in particular for the purpose of granting or taking the oath of citizenship. Youth criminal justice records and ongoing proceedings before the Youth Criminal Justice Court cannot and should not be considered for the purpose of citizenship applications because to do so is contrary to the Youth Criminal Justice Act, specifically violates the privacy protections afforded to minors by the Youth Criminal Justice Act and is inconsistent with the fundamental purposes of the Act itself. I think this is a valid point, Mr. Chair, and we want to ensure that the Citizenship Act and the citizenship process adheres to the principles and laws under the Youth Criminal Justice Act accordingly. So this amendment seeks to remedy that, Mr. Chair.
Thank you, Ms. Kwan. It is admissible. Debate. Mr. Asasi.
Thank you, Mr. Chair. If I could make a few points with respect to this amendment as it's being proposed by my colleague. First of all, I assume the reason or the rationale in this particular instance is that you would propose to de-link criminality from application for citizenship under Section 5.2 of the Act. I think it's essential to inform members of this committee that under the current law, individuals, including minors, must be free of criminality for at least 4 years. So that's how it currently stands. That having been said, the qualifier is that it's only for serious criminal charges. So bearing all those points in mind, I see no compelling reason why we should vote for this, and I would vote against it.
Ms. Kwan.
Just one other piece, of course, to consider, and that is the issue around privacy protection afforded to minors.
Seeing no further debate, I will call the vote on the amendment. All those in favor? Opposed? The amendment fails. Moving to NDP.
On division, Mr. Chair. Just have the.
Thank you.
Thank you.
NDP 17. Reference number 8191596. Ms. Kwan.
Thank you, Mr. Chair. Just let me make sure I've got the right one. Right, so NDP 17, so this is an amendment seeks to eliminate the bar to citizenship for those charged with or convicted with offenses equivalent to indictable offenses in Canada. We heard from a range of organizations, Mr. Chair, the Canadian Bar Association, the Canadian Council for Refugees, Metro Toronto Chinese and Southeast Asian Legal Clinic, individual Peter Edelman, and the Ontario Legal Aid. The goal of this amendment is that not all, as we know, that not all justice systems in the world are equal. Most importantly, some countries deal with corruption at various and or municipal levels of justice and political systems, from local police to national leaders. This can and does not lead to, and does lead to unjust charges and convictions. We know of situations too, as well, where charges are politically motivated. For example, individuals in this situation are of some of the most vulnerable, Mr. Chair, and barring them from citizenship to Canada is another instance of injustice. The situation should be reviewed on a case-by-case basis, not to say that they should all automatically have access to citizenship, but rather to say that they should all be reviewed on a case-by-case basis, Mr. Chair. There were some great examples that were highlighted in our presentation. I think Mr. Fahmy was illustrated as a case in point why a automatic exclusion of citizenship would be a unfair approach in proceeding in this act. So my amendment seeks to remedy that, those kinds of situations, Mr. Chair. So I move amendment number 17, NDP 17 in my name, reference number 8191596, accordingly.
Thank you, Ms. Kwan. The amendment is admissible. Debate. Mr. Sarai.
I think it would result in an unequal treatment of applications. It's already enshrined a criminal act committed elsewhere has to have a Canadian equivalent, so it would prevent any misuse or abuse that might happen. In the case of Al-Fabi, I think that would not be a criminal offense in Canada, and therefore it would not apply to a situation such as him. Moreover, I think there are safeguards the minister has the ability to waive on compassionate grounds. And lastly, I think there's a 4-year period of if you've had a criminal record, and as long as you haven't had it for 4 years, I believe you can get citizenship. So there are means to get around that for those that perhaps might not have the equivalent or might have had different circumstances under which their criminality was considered. So I think we have the safeguards, and this isn't needed.
Thank you, Mr. Sarai. Ms. Kwan?
Yes, just to respond, Mr. Chair, that of course makes the assumption that in other jurisdictions that their criminal justice systems are not without issues or challenges, and as we know, that is not the case in some countries. As we know, there are issues of corruption amongst other challenges as well, and this remedy recognizes that, and as I said, is not a remedy to say everyone should automatically be granted citizenship, but rather to say that it should be considered on a case-by-case basis. And I think that's a fair way to proceed, Mr. Chair.
Thank you, Ms. Kwan. Seeing no further debate, I'll call the vote. All those in favor? Opposed? The motion is negative.
On division, please, Mr. Chair.
On division.
Thank you.
NDP 18 was withdrawn, so we will proceed to NDP 19. And that's reference number 8223272.
Thank you, Mr. Chair. This amendment seeks to repeal the provisions of the Act that provide for federal court review or appeal only with the leave of the court, and thereby making judicial review unavailable. Oh, hang on, I'm ahead of myself. That is actually NDP 20. So let me come back to NDP 19. Mr. Chair, this amendment is a companion piece to the issue that I had raised earlier that was defeated with respect to amending the Act to address and accommodate the issues around the Youth Criminal Justice Act. This amendment is really a companion piece with respect to that, so I won't belabor the point, but rather to ask that the committee consider the comments that I made earlier related to that amendment.
Thank you, Ms. Kwan. Debate? Seeing none. Mr. Tabarra.
For serious criminality, is it in the interest of Canada to prohibit permanent residents who have committed serious crimes from becoming citizens? As my colleague mentioned in the other amendments, that there's individuals must be free of any criminal charges for 4 years before applying for citizenship. The minister has a discretion to waive criminality on compassionate grounds or where there is unfounded charges.
Thank you, Mr. Tabarra.
The same issues, because we're dealing with youth and minor, the issues around privacy also applied as well, and as we pointed out by the witnesses around the concerns around breach of privacy.
Thank you. Seeing no further debate, call the vote. All those in favor? Opposed? It's negatived.
Division, please, Mr. Chair.
On division. Thank you. So that concludes the amendments to Clause 10. Shall Clause 10 carry? All those in favor? Opposed? Carried. There's a new clause 10.1 that's a result of NDP 20, which is reference number 8220121. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment seeks to repeal the provisions of the Act that provide for federal court repeal or review or repeal only with leave of the court, and thereby making judicial review available according to the Federal Courts Act as for any other decision under federal law. A number of witnesses before the committee came forward and called for this change and supported this kind of change, and that include the Canadian Council for Refugees, the Metro Toronto Chinese and Southeast Asian Legal Clinic, the Canadian Bar Association, the Ontario Legal Aid, and an individual, Audrey Macklin. The goal here is to remove the requirement for leave of court to obtain judicial review and or appeal of citizenship refusals at federal court. The concern around having to seek leave, of course, is an onerous requirement by many, and that's been identified and stated by the witnesses who came forward. And this amendment seeks to remedy that.
There's a point of order, Mr. Tilson.
NDP 20 or 21?
20.
20.
Please
So,
proceed.
so anyway, I was done, and this amendment seeks to remedy that. So I move amendment NDP 20, reference number 8220121.
Thank you, Ms. Kwan. The amendment seeks to amend a section of the Citizenship Act that is not amended by the bill, and it's therefore the opinion of the chair that the amendment is inadmissible.
Thank you, Mr. Chair, for that ruling. And again, this amendment, I think, is another important one related to process. Perhaps it was an oversight at the time when the government brought in Bill C-6 that didn't address this. And it makes a better process. It makes for a more efficient process and a less costly process for individuals who are faced with such a circumstance. So I hope that the government will take this into consideration for potentially a fall piece of legislation around this issue.
Thank you, Ms. Kwan. The next amendment is NDP 21, reference number 8222922.
Thank you, Mr. Chair. This amendment is a companion piece to what I called or refer to as the Carl Amendment, and that is the amendments number NDP number 10 and 21. And it really aims to create greater certainty with respect to an application for judicial review with respect to any matter under this Act. And that it may be made in accordance with the Federal Courts Act. Given that the previous amendment was deemed to be out of scope and out of order, I'm not quite sure whether or not this will be deemed to be in or out of scope, assuming likely out of scope. And with that, hopefully this then would be considered as well as a companion package to the other amendment later on in the fall by the minister.
Thank you, Ms. Kwan. You're quite correct. And in the opinion of the chair, the amendment is inadmissible for the same reasons. Which brings us to Clause 11. There are no amendments to Clause 11. Shall Clause 11 carry?
Yes.
All those in favor? Thank you. Clause 12. We have an amendment, NDP 22, reference number 8191635.
Thank you very much, Mr. Chair. This amendment seeks to eliminate the requirement to pass a knowledge test in one of the official languages. And presenters that came before the committee included the Canadian Bar Association, the Metro Toronto Chinese and Southeast Asian Legal Clinic, and individual Peter Edelman, and also the Canadian Council for Refugees, who also support this amendment. And they raised the point, I thought, quite eloquently. The amendment here, under the changes made by the former government, the Conservatives, the knowledge test of Canada as required to obtain citizenship now amounts to a double testing of language skills. Prior to the Conservative changes, individuals had the ability to take the test with the aid of an interpreter. And due to the changes, the interpreter is no longer provided, and this amounts not only to a second language test, but a language test that is arguably more difficult than the actual level of English or French someone must have to pass the actual language test. So this amendment, Mr. Chair, seeks to remedy that. I would also advance this issue as well at this time. There really should be the opportunity to forward an amendment to eliminate the upfront proof of language levels as well on the question around proficiency. But as that matter is dealt with by regulation, no amendment can be advanced to deal with that. That issue was advanced by, again, a number of the witnesses before us. And for many, particularly refugees and some immigrants, the proof of language levels is such an onerous measure that many of them would not be able to meet. And so in that regard, hopefully the government will take into consideration of the witnesses' presentation around that issue and make changes to the regulation. But at this point, because that would be out of scope, my amendment is only to deal with the double testing issue. And that's amendment number 22, NDP 22 in my name, reference number 8191635, Mr. Chair, and I move it accordingly.
Thank you, Ms. Kwan, and the amendment is admissible. And I'd like to bring to the attention of the committee that PV 8, which is reference number 8223261, is identical in intent, in fact, identical in wording. So if NDP 22 is adopted, it cannot be moved as they are identical. And if NDP 22 is negatived, so is PV 8, as they are identical in wording. So, debate. Ms. Zaid.
Thank you, Chair. I would like to speak in regards to Ms. Kwan's amendment. Right now, the way it is worded in the Act, it provides clarity on how citizenship applicants are going to demonstrate knowledge of Canada, ensuring that the requirement is met in both official languages, English as well as French. And when the Minister was here, he indicated previously that he is in the process of reviewing the book on Discover Canada Guide, including its language level. So I would vote against this because it is very important that we recognize that the applicants have already several chances to retake the test. If in case they fail the first time, they have another chance to retake the test. And also, language proficiency is critical, as it is one of the key determinants of how successfully the new immigrants can integrate into the Canadian society. So for these reasons, I will vote against it.
Ms. Kwan.
Thank you, Mr. Chair. I'm just speaking to the points that has been raised by Ms. Said. I think I want to state this on the record. I don't think anyone is in a disagreement that knowing English or French, either official language, is important. I would be the last to argue to say that it is not important. But the issue here is this. Immigrants, refugees, others who have English or French as a second language may have some real-life experiences or situations to which they're faced that would prevent them to acquire the level of proficiency that might be required to gain access to citizenship. In some instances, I'll use my own personal experience. My mother has a grade 6 level of education from China in her first language. She is now 83. And she became a citizen many years ago. I, along with my sister, became a citizen under her application. At that time, when she applied for her citizenship, she was able to get an interpreter to get the test passed. That's how she became a citizen. Had that not been afforded to her, I suspect that, I mean, who knows, maybe I would have applied for citizenship on my own. Maybe not. Who knows what circumstances may lead me to become, and for my family, what that outcome might be. And for an immigrant family like mine, we're a low-income family when we came. My mother worked first as a farm worker. She made $10 a day as a farm worker. She later graduated to become far more proficient, and she became a dishwasher. And she worked until she retired at 65. After 2 years of being a farm worker, got enough English to get through her work and to participate in the community and voted and did all of those things. But if the test requirement were to apply today to her, then for citizenship, I dare say she would not pass. And I don't think that's right. And it doesn't mean to say people like her, and I'm not unique, by the way. This is a very common issue, and I know that members will know this from your own constituents, that this is a real issue. So yes, the minister's looking at reviewing the books and doing this and that and the other thing, but this does not preclude for us to have a better system in place and to facilitate access to full participation as a Canadian citizen. That's what this is aiming to do. And that's what the witnesses before us said that we should try to accommodate as well. So I urge the members to consider. I get it that I only have one vote, such is life, but I would appeal for the members to consider that because it's real and it impacts a lot of people.
Thank you, Ms. Kwan. Seeing no further debate, all those in favor? Opposed? Negatived.
On division, please, Mr. Chair.
On division. NDP 23 was, and that also means that PV 8 is negatived at the same time. NDP 23 has been withdrawn, which means that we are now, there are no further amendments to Clause 12. So I'll call the vote on Clause 12. Those in favor? Opposed? Carried. Clause 13. There are no amendments. All those in favor? Opposed? Carried. There is a Clause 13.1 as a consequence of NDP Amendment 24, reference number 8213783. Ms. Kwan.
Thank you very much, Mr. Chair. This amendment calls for changes to the Canadian Citizenship Oath to comply with the Truth and Reconciliation Commission recommendation number 94. It aims to comply with the Truth and Reconciliation Commission's recommendation to include faithfully observing the treaties with the Aboriginal peoples of Canada to the citizenship oath. As we know, that the government has already made a commitment that the government would adopt all of the recommendations from the Truth and Reconciliation Commission, and that includes recommendation 94. So to that end, the proposal is to change the oath to read as follows. I swear or affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada, including treaties with the Aboriginal peoples of Canada, and fulfill my duties as a Canadian citizen. So to that end, Mr. Chair, I move my amendment under my name, NDP 24, reference number 8213783.
Thank you, Ms. Kwan. The amendment seeks to amend a section of the Citizenship Act that is not amended by the bill, and it's therefore the opinion of the Chair that the amendment is inadmissible.
Thank you very much, Chair, for that ruling. And again, I would ask the Minister to consider bringing this piece of amendment to a later date. I think is particularly important given the government's commitment and stated principle that we're now in a new era and an era of a new nation-to-nation relationship with Indigenous peoples of this country.
Thank you, Ms. Kwan. Which brings us to NDP 25, reference number 8222219.
Okay, we're almost there. Thank you, Mr. Chair. This amendment deals with a previous amendment that was tabled, and that is the leave of court provision, Mr. Chair. And this is really a consequential amendment related to that piece. So I won't belabor the point, but rather we'll proceed to the vote accordingly.
Thank you, Ms. Kwan. It is the opinion of the Chair that the amendment is inadmissible. Which brings us to Clause 14. And the House of Commons Procedure and Practice on page 999 states that committees may decide to group a certain number of clauses and vote on them together, such as those that were not the subject of any amendments. In this case, We have clauses 14 through to 25 that have no amendments, and we can vote on them as a group with the committee's consent. Do you have? 14 to 26. Oh, sorry, 14 to 26 have no amendments. Do we have the committee's consent to vote on them?
No.
No? Okay. We do not have consent. So we will proceed to voting on Clause 14.
Oh, Mr. Chairman, I'd like to speak against Clause 14.
I see.
This is this makes the bill retroactive to the date of coming into effect of C-24. And this opposition has been expressed in the House, but I'd like to express it again. Effectively, the bill means that the government will be returning citizenship to Zachariah Amara, who was the ringleader of the Toronto 18 terror group, which planned al-Qaeda-style violence in southern Ontario to push Canada to abandon Afghanistan. The faction led by Amara built detonators and acquired explosive materials for large truck bombs that were to be detonated in 2006 near the Toronto Stock Exchange and CN Tower. An Ontario military base was also to be attacked. Parliament was on the list of targets, and it was planned that the Prime Minister of Canada was a target to be beheaded. So there was a piece in the National Post, Mr. Chairman, which I'd like to briefly quote part of it. It was in February 25th of this year, because it essentially, this section will reinstate this man's citizenship. The plot by the al-Qaeda-inspired Toronto 18 to detonate truck bombs, storm the CBC and the Canadian Parliament, and then behead Prime Minister Stephen Harper was foiled 10 years ago. As the trial judge said, the potential for loss of life on a scale never seen before in Canada was spine-chilling, and those were the judge's words. Right-thinking Canadians everywhere will then be relieved to learn that the man who masterminded these terror attacks was subsequently given a life sentence and is the main beneficiary of the Liberal government's Citizenship Act reforms, because that's what Section 14 will do. Zachariah Amara had his Canadian citizenship stripped under a bill, and I'm still reading from the National Post. Zachariah Amara had his Canadian citizenship stripped under a bill brought in by the Conservative government in 2015. Under the legislation just introduced by the Liberals, he will have that Canadian citizenship reinstated. The Conservative Strengthening Canadian Citizenship Act ensured dual citizens convicted of terrorism, high treason or spying would have their citizenship revoked. So, Mr. Chairman, I just draw to the committee's attention that by passing this legislation, this man who intended to do all these, to use the judge's words, spine-chilling events to institutions, the CBC, Parliament, beheading the Prime Minister, that his citizenship will be reinstated. And quite frankly, that's not good. In fact, it's terrible. So I urge members to vote against this retroactive section.
Thank you. Shall Clause 14 carry? All those in favor? Opposed? Recorded vote.
A recorded vote on Clause 14. Mr. Chen.
Aye.
Mr. Asasi.
Aye.
Mr. Sarai.
Aye.
Mr. Tabara.
Aye.
Ms. Zahid.
Aye.
Ms. Rempel?
Nay.
Mr. Soroya?
Nay.
Mr. Tilson?
No.
Ms. Kwan?
Aye.
Thank you. The clause is carried. Currently, we have clauses 15 through 26, which have no amendments, and we can vote on as a group with the committee's consent. Do we have the committee's consent?
We're opposed to 25 and 26.
Thank you for that help in identifying where the problem may be.
We have no problem with the first group, but 25 and 26 we're opposed to.
15 through 24. In that case, 15 through 24, do we have the committee's consent to vote on them as a group? Thank you. So we shall vote on 15 through 24.
Just a point of clarification, Mr. Chair. Did you mention clause 26 in that as well?
No, 15 through 24.
Sorry. My apologies.
Yes. So 15 through 24. All of those in favor? Opposed? Carried. Thank you. Which brings us to clause 25. Mr. Tilson, I believe you wish to speak to clause 25.
We're opposed.
Sorry?
We're opposed to it.
Thank you. Seeing no further debate, all those in favor of clause 25? Opposed? Carried. Clause 26. Shall clause 26... Oh. Mr. Tilson.
We're opposed.
Thank you. All those in favor of clause 26? Those opposed? Carried. There's a new clause, 26.1, which is a result of CPC 3, Amendment 3, reference number 82222415. Mr. Tilson.
Thank you, Mr. Chairman. Essentially, this is a 5-year review clause proposed in the amendment, and it would add a 5-year review clause to trigger a parliamentary review 5 years after the coming into force. The text of the clause is before you, but I would like to read it. At the start of the 5th year after the day in which this Act receives royal assent, the provisions enacted by the Act are to be referred to the Committee of the Senate of the House of Commons or of both Houses of Parliament that may be designated or established for the purpose of reviewing the provisions. And the subclause 2, the committee to which the provisions are referred to is to review them and submit a report to the House or Houses of Parliament of which it is a committee, including a statement setting out any changes to the provisions that the committee recommends. Mr. Chairman, I believe it's reasonable that this committee review the progress and the state of this legislation from time to time. It's not an unusual request, the sunset type clause. 5-year review clauses are not uncommon in here or in other committees, and it seems that this is an appropriate piece of legislation to contain one. Our immigration patterns over the past quarter century have shifted, and that is unlikely to change. It seems prudent, Mr. Chairman, to include a 5-year review clause to monitor the health of one of Canada's most precious commodities, and that is of our citizenship. So this C6 is making some substantial changes to the law, and I think it's fair, Mr. Chairman, that we need to monitor. We've heard witnesses make some submissions. The committee hasn't agreed with some of them. We've agreed with others. And I think it's prudent that this committee pass this section to give us an opportunity in 5 years' time to review what we have done.
Thank you, Mr. Tilson. Mr. Chen.
Thank you, Mr. Chair. This amendment is simply unnecessary. It essentially establishes a sunset clause on Bill C6, and as this committee well knows, the committee has the authority and power to conduct any study at any given time on any citizenship or immigration program in this country. And simply by passing this amendment to ensure that after a 5-year period that there is an automatic study and review that is carried out is simply not necessary. In fact, the committee may wish to look at some aspect of the legislation and how it has been and its effects before the 5-year period is up. I think simply by the nature of the authority that this committee has, it's not needed that we have this amendment, so I will not be supporting it.
Thank you. Ms. Rimpel?
Through you, Mr. Chair, I'm wondering if Mr. Chen can explain how this creates a sunset clause.
Ms. Kwan was next on the list.
Sorry, I was going to ask on a point of clarification exactly that issue around sunset clause, and also with this amendment, to my understanding, this does not preclude any changes that would be made by the government in terms of amending the act itself at any time. I think that all this amendment is to call for it to be reviewed by committee in terms of how was the act. How did it work? But it does not preclude any of those actions, nor is it, to my understanding, a sunset clause. So if I'm incorrect in understanding this, I would appreciate it if someone identify that for me so that we can be clear on what the intention of the amendment is.
Mr. Chen.
Thank you, Mr. Chair. To clarify, I said specifically that it was essentially like a sunset clause, and not to say that the amendment itself is a sunset clause. The wording of the amendment says that with this review, that there be a statement setting out any changes to the provisions that the committee recommends. And in some sense, you are essentially saying that there needs to be changes. And I would humbly suggest that if committee members have changes to propose, that this is the venue to do so, as we have been discussing over the past couple hours. And at any time, if the committee wishes to study the legislation or its impact over the coming years, as well as conduct essentially any study it wishes on any citizenship and immigration program in this country, the committee has the authority to do that. I don't see the point of having this amendment set in stone, the 5-year review.
Ms. Rimpel.
Well, Mr. Chair, by that logic, my colleague opposite has negated the Minister of Health in saying that Bill C-14 requires a 5-year review, which is part of the bill that we're debating in the Commons today. So there's a bit of a dichotomy there, or a lapse in logic. I would direct a question to the department officials, and perhaps if they can inform the committee of the commonality of 5-year reviews in terms of legislation. As well as if they could elaborate on whether a parliamentary review would constitute a sunset clause of this particular piece of legislation.
Ms. Dekranian.
Mr. Chair, I'm not sure I can elaborate how common a 5-year review is in legislation. I don't have that information as well. No, our understanding is this would create a requirement for a review in 5 years, but not a requirement as a sunset clause.
Thank you for that clarification. Mr. Tilson.
Mr. Chen is correct, and I misspoke when I said it was a sunset clause. You're absolutely right, Mr. Chairman. It is not a sunset clause, but what I'm asking for, that in 5 years' time there be a review of all that is going on. There may be other things as well, and I think if it's on the record that we are to review it, I think that's a good thing. Immigration is a continually evolving issue in this country. We're most generous, perhaps one of the most generous jurisdictions on the planet, as far as encouraging new Canadians to come to this country and become citizens. But I think it's appropriate that we have a review in 5 years. So I do apologize, Mr. Chen, for
thank you, Mr. Tilson. Mr. Virani.
Mr. Chen has offered me some of his time. In respect to this issue, it's critical to understand that this committee is the master of its own process. And apropos of what Mr. Chen has indicated, that matters that the committee wishes to study can be determined by the subcommittee on procedure here at this committee, earlier than within a 5-year period or later than within a 5-year period. In terms of the point made by Ms. Rempel as to whether there's an inconsistency by not implementing a mandatory review in this legislation with what is transpiring with the C-14 issue, that is entirely there's absolutely no inconsistency, because that undermines the notion that somehow what is applied for one piece of legislation under a different minister, under their mandate, must therefore ipso facto be applied to every single piece of government legislation that is being enacted by the Government of Canada. That is clearly not the way this government operates, nor is that the way that any government has operated. Decisions that are made with respect to whether mandatory reviews are required are made in consultation with ministerial or departmental officials relevant to that ministry and relevant to that minister's own decision making, and also germane to the issues that are at issue within that specific legislative context. The position being articulated by Mr. Chen is that in the context of this legislation, it does not meet that threshold requiring a mandatory review, particularly when you have a standing committee populated by members of all three parties that can initiate such a review on their own volition.
Thank you, Mr. Virani. Ms. Rempel.
Mr. Chair, I would respectfully disagree with my colleague, because my colleagues that sit on the government committee here are solely using the point that this legislation does not require a 5-year review because the committee is the master of its own domain. By the same logic, the Health Committee should be able to look at the issue contained in Bill C-14, yet the government has stated that it is material enough to require a review in 5 years. I respect the fact that the government I'm not sure what they would have to hide or why they would vote against a 5-year review, especially in light of the Auditor General report that we saw today on instances of fraud being not detected within the Department of Citizenship and Immigration. But I find that my colleague is perhaps grasping at straws to justify his logic. Thank you.
Can I speak to that, Mr. Wisniewski?
Well, Ms. Kwan is next on the list.
Thank you.
Thank you very much, Mr. Chair. On this amendment, I would actually support it. I think that to do a review 5 years hence is not a bad thing. To my understanding, it does not mean that the changes made in C6 would come to an end. So that is to say that it is not a sunset clause at all. The laws that have been passed accordingly after we receive third reading in the House will continue to be the law. It only means that it should come back as a bill to be reviewed by the committee and to determine or have an evaluation of how the changes had been. The reason why I support this is this. For example, I raised a number of amendments, though few of them were in scope, but the majority of them were defeated by the government members. The government members' argument is that we already have provisions in place, the ministers already have those authorities, this is not an issue, and so on. But in reality, is it going to turn out like that, to say really is not an issue? So from my perspective, it's worth looking into to see 5 years hence, am I right or are the government members right? And if my concerns are not valid, it'd be really good to actually, after 5 years, to come back to indicate that and then say, okay, then I don't really actually have to worry about that, and it was all going to be okay. And those issues were in fact addressed through different provisions, etc. So to that end, I would support this review, and that's all that it is. It's just a review, and it does not create a sunset clause for the Act itself. nor does it preclude the government in bringing forward additional amendments to which we talked about at this committee meeting, which I suspect and hope that will be forthcoming in the fall.
Thank you. Mr. Virani? Yes.
Mr. Chairman, past 2 o'clock. It's almost 10 after 2 o'clock. The agenda stated that this meeting would end at 2 o'clock. All, if not most of us, are required to attend question period, which started 10 minutes ago. So I would suggest we adjourn the meeting.
As I've been advised, you cannot move a motion to adjourn on a point of order, so it's just a suggestion.
I was making a request to you as the chairman. You set the agenda. You said the meeting would end at 2 o'clock if you require a motion, but you, sir, set the agenda of this committee, and the committee was to end at 2 o'clock. So I would suggest that by your own terminology, the meeting adjourned.
Is it the will of the committee to adjourn at this time? I don't see consensus on that.
What's consensus? The government decides?
Mr. Tabarra?
I think we should just finish with the agenda. We have a couple more. I think we can get through it real quick, and then we can be on our way.
We will definitely miss question period, Mr. Tabarra.
No, we won't.
Yes, we will.
Let's not get in a debate across the table. Thank you, Mr. Tabarra. I believe that there's no further debate, so I will call the vote on CPC.
Mr. Chair, I was on the list.
We didn't see you on the list, but we can add you to the list, Mr. Chen.
Thank you, Mr. Chair. I just want to respond to my colleagues across the way, and first to Mr. Tilson through you, Mr. Chair. I do accept the apology, and I thank you for the forthrightness you have demonstrated in the spirit of collaboration. With respect to Ms. Rempel's comments around a contradiction, I would humbly suggest that the contradiction is in fact on the other side, because it was in fact her colleague, Mr. Tilson, who suggested at an earlier committee meeting that this committee is independent and is not here to carry out the wishes of the minister. So I would argue...
Point of order, Mr. Chairman. Those discussions were made in camera, and Mr. Chen has absolutely no right to raise issues that were discussed in camera.
Point of privilege.
So you have a problem,
yes,
Mr. Chairman.
Point of privilege.
Thank you, Mr. Tilson. You are in fact correct, Mr. Chen. You may not raise issues that were discussed in camera.
My apologies through you, Mr. Chair. I was not. I did not recall that was.
Well, Mr. Chairman, I'm going to speak on a point of privilege. I quite frankly have never seen this happen in this committee in the years that I've been here in this committee, of where members reveal what other members said in camera. The purpose of meeting in camera is to discuss open matters of business, how we're going to proceed, and other matters. And quite frankly, Mr. Chen is completely wrong in quoting me as to what I said in camera. And I don't think you should just dismiss this and say, Mr. Chen, you're not allowed to do that.
So a point of privilege has been raised. Mr. Chen has made it clear that he was not aware that the discussion that he referenced was in camera, and he has apologized. Ms. Rempel.
Mr. Chair, I raise a point of privilege, given that this, by your own admission, was a release of in-camera information on the record in public. I believe that is a violation of privilege, and per proper procedure, I ask that you report this incident to the House of Commons.
Ms. Rempel. Mr. Chen did make it clear that he was not aware that he was referencing something that was discussed in camera. He has apologized, and that satisfies me in regards to the question of privilege. Ms. Rempel.
I've asked this be reported to the House of Commons, given by your own admission that this was a violation of in-camera ruling. This is a very serious breach. So if you are overruling that request, then I challenge your decision and ask for a recorded division.
Thank you.
The question is, shall the decision of the chair be sustained? Mr. Chan?
Aye.
Mr. Asasi?
Aye.
Mr. Sarai?
Aye.
Mr. Tabara?
Aye.
Ms. Zahi?
Aye.
Ms. Rempel?
Nay.
Mr. Soroya?
Nay.
Mr. Tilson?
No.
Ms. Kwan?
Nay.
The decision is sustained, and we shall move to voting on CPC 3, reference number 8222415.
Mr. Chairman,
All those in favor?
Mr. Chairman, we've now, question period officially starts. It's absolutely unheard of that you would proceed in this fashion. I therefore move we adjourn.
Mr. Tilson, you have already tried to move that motion. It was not supported.
Chairman, we've had proceedings since that took place, and we're now into another motion.
Seeing no debate, all those in favor of the motion? Opposed? Yes, sorry.
Just a point of clarification, Mr. Chair. Is the only item that we need to deal with respect to this is to vote on the amendment, the last amendment, and then we're completed all of the items that we're to address before this committee today?
Clause 27, which has no amendments, and then we vote on the title, the bill, and reporting the bill to the House, and ordering a reprint of the bill, which are procedurally pretty quick. So all those in favor? Opposed? So the motion does not carry. So we move to CPC 3, reference number 8222415. All those in favor? Opposed?
I'm sorry. Can you just repeat that?
CPC 3.
Oh, I see.
Reference
yes,
number
yes, okay.
8222415. All those in favor? Opposed?
In favor, Mr. Chair.
Okay.
Of that
Thank
last
you.
amendment. Yeah.
The motion is negative. Clause 27. There are no amendments. All those in favor of Clause 27? Thank you. Carried unanimously. We now move to the title. Shall the title carry? All those in favor? Carried. Shall the bill carry as amended? Carried. Shall I report the bill as amendment? Carried. Shall the committee order a reprint of the bill? Carried. Thank you. Meeting is adjourned.
Oh, sorry.
Oh.
Sorry, before you adjourn the meeting, I just want to ensure that there's a point of clarification. There were moments in the meeting where I think Mr. Tilson had called for on division, and then, Mr. Chair, you didn't call for another vote around. And I just want to be sure that it's recorded accordingly in terms of my vote on the items where I stated that I would oppose it, those are the items that I'm opposed to it, but on the items where I'm not, where I hadn't stated that, then I'm actually in support. So I just want to be clear about that because there was some confusion, at least in my own mind, as those proceedings were carrying forward.
Yes. I noticed at times you would raise your hand, so I will just verify and make sure with the clerk that, in fact, all of that is clearly noted.
Yes, so because where every time Mr. Tilson called for on division, I'm not sure if that meant that it was going to be same as the previous vote in terms of the recorded positions of each member, because there were some times when I wasn't in support of Mr. Tilson's position. So I just want to be clear about that, so there's no misunderstanding about how I voted.
Thank you, Ms. Kwan. Meeting adjourned.